truth of the matter is, I've never entertained even the slightest suspicion that this one time, at least, I was mistaken.
The rule we laid down in Betts was that a lawyer is constitutionally required only if to be tried without one amounts to a denial of fundamental fairness. We said that flexibility should govern us.
I felt then, and I feel now, that we need an absolute rule. Right to counsel may not be deemed an essential to a fair trial in some countries, but it is in ours.
And I think there's considerable danger formulating hard and fast rules which ignore qualifying factors and then imposing those rules on the states against their wishes. That's what we decided 20 years ago. And I think it is still a valid approach. Flexibility.
Well, I think that I'm a flexible man in most respects, but not about the rights of an accused person.
Well, I've got a basic difficulty with the question. Should we be preempting the prerogatives of Florida courts, and especially their legislature? And if they believe that everyone is entitled to a lawyer and they'll pay for it, let them say so.
And if they don't believe that, or they don't choose to pay for it, what happens to Gideon? Who does he turn to for protection?
I've read his petition. He seems of average intelligence. He could defend himself without a lawyer.
Not adequately.
But when is someone entitled to counsel? As soon as he's arrested? When he's arraigned? When he goes on trial?
But if we're going to talk about practical consequences, how many prisoners are there in this country right now who didn't have a lawyer?
Too damn many.
And if we're going to rule now that the Gideon trial was unfair, so was theirs. So what are we going to do about it? Order a new trial for every one of them?
I'd like to bring this back to Mr. Gideon. The other side had a lawyer. Is it fair that he should not have one? Isn't that the question?
All right. This was a very simple case. Breaking and entering to commit petty larceny. And even a simple man, presuming Mr. Gideon is a simple man, something that may not be safe to presume at all, even a simple man can defend himself in a simple case.
But is it fair? Is it fundamentally fair?
Petty larceny it may have been. A petty sentence it was not.
These are all extremely important questions that can be decided if we hear the case. Is there any sense yet whether we ought to accept it?
Clarence! Clarence! Hey, Clarence! Hey! You got 2 letters from the Supreme Court. 2 of them. You hear me?
I hear you.
That's some mail for me.
Ain't you gonna open them?
Gideon versus Cochran. A motion for leave to proceed in forma pauperis and the petition for writ of certiorari are granted. I assume you desire the court to appoint a competent attorney to represent you in this court. It will therefore be necessary for you to forward immediately a handwritten motion requesting the court to appoint counsel to represent you. All it means is they agreed to hear it. I still got to win it.
The question is very simple. I requested the court to appoint me an attorney, and the court refused. Is that a simple question, Mrs. Lawrence?
Excuse me, Mr. Fortas.
Mr. Gideon says the question is very simple. Does the Constitution entitle a poor man charged with crime to have a lawyer at his side?
You mean it doesn't?
No.
But if you're asking me, Mr. Fortas, no question about the law is very simple.
Which is exactly why Gideon needed a lawyer in the first place.
I haven't had a chance to congratulate you yet, sir, on being appointed to represent Gideon.
Thank you, John, and I count on you to help prove that I'm worthy of it. Abe will organize the research and work with me on the preparation of the brief. Jim, you'll do the research, and John will help you until he has to go back to law school. I want memoranda on how state law on appointment of counsel has changed through the years. In factual terms, how many felony defendants go to trial without counsel? If the Constitution is now held to require counsel in all cases, what are the additional demands on lawyers? I want your ideas on what the shape of a suggested rule should be. Are we arguing that people charged with misdemeanors should have lawyers?
Well, some of the justices are going to find that hard to buy. Now, maybe we should just argue felony cases.
The Supreme Court has asked me to argue whether everyone is entitled to a lawyer. But I don't represent everyone. I represent Clarence Earl Gideon. If I can get him out of prison on any grounds at all, if I can show that there were special circumstances that entitled him to counsel, insanity or incompetence or whatever, you can't tell from the written record, but maybe Gideon is a black man. I could argue that in the South, a black doesn't have the same treatment as a white man. If I can get him out in any way at all, isn't my first duty to Gideon?
Absolutely, Abe. There are a few things that Supreme Court justices like less than a lawyer who sets aside his client's interests in his zeal to make some great change in the law.
It would be an anticlimax if they were to free Gideon without laying down a new rule for right to counsel, but I'm going to find out if there were any special circumstances. Add this, please, to my letter to Gideon. As a matter of my own interest, I would be very glad to receive from you a careful and detailed biographical description. When and where you were born, education, employment, family, arrests, any information that may come to your mind. I want to emphasize that this is not at all necessary, but will serve only to give me a little background. I know that you will be extremely careful to be absolutely accurate in any information you send along to me.
My mother's very strict. My life as a child was of the strict discipline. My parents lived by the best moral customs and were members of the Calvary Baptist Church, which I joined when I was around 13 years of age. My mother still to this day has done nothing that could be classed as wrong. Also, my brother and sister of the best kind of character. I suppose I am what is called a individualist, person who will not conform.